Immigration attorney Sharifa Tharpe. I'm here live to take your questions. I also have a great topic for you today. Now, you've been barred. That means that you've been found inadmissible in some way, and you are trying to figure out how to go from being barred to getting permanent residence in the United States. And I'm going to talk about the two, three of common bars that happen in immigration, usually when there's some sort of immigration violation, and then how to get back from that to overcome it and get the green card while being in the United States. So, when I talk about barred, I'm going to talk about three scenarios. So, one is where you have been permanently barred. Yes, where you've been permanently barred from getting an immigration benefit, it is possible to come back from that. And usually, a permanent bar happens in these cases. The first is where you have been charged under immigration law, not necessarily criminally, but been charged under immigration law with immigration fraud or misrepresentation. This usually happens when you present fraudulent documents, or you tell a lie, or even when you omit intentionally, maybe willfully omit important information that would have made a difference in your case in order to get the immigration benefit. So, for example, say you went to go and get your green card through a parent and you were married, but you put on the application you weren't married so that it could go through faster. That's an example of misrepresentation or fraud. Another common scenario is maybe you came into the country, you may have succeeded, and you came in with a fake passport. That's also considered misrepresentation or fraud, even if you weren't caught then. When you do have to later on, when you're applying for an immigration benefit, and you do have to later on admit that the way or describe the way that you came into the country, you're going to have to let them know that you came in using someone else's passport. And if not, then at that point, they're going to definitely find that you have misrepresentation or fraud, and they're going to determine that you are permanently barred. Another situation is where you came into the country, you overstayed for a year, and then you left and came back in. You either left or you were ordered removed. So you now have unlawful presence for over a year. You came back into the country, and then at that point, when you came back into the country, you came in without inspection. You either attempted to, or you succeeded at coming in without inspection the second time after being removed or after leaving. Then that can lead to a permanent bar, meaning that you're not able, you have to, in order to get any immigration benefit to begin with, there's a permanent bar, but you can only apply 10 years of being outside of the country. That's when you're able to apply to then come back in, and you have to submit special waivers, starting with what's called permission to reapply for re-entry. And then the others, if you were removed, if you were removed from the country and then you came back in without inspection, that is also can lead to a permanent bar. So now that I've explained some of the scenarios that do lead to permanent bars, let's talk about the two ways that you could possibly overcome that. And I'm going to talk about the one that you always hear me talk about. It's VAWA. Now, VAWA is one of those forms of relief under immigration law that still allows you to overcome that permanent bar under certain circumstances. So, for example, if you can show that the exit and entrance, or the entrance leading up to the permanent bar, was in some way linked or substantially linked to the mistreatment or the abuse or extreme cruelty by the relative, either the spouse, the parent, or the adult citizen child, then it means that you could overcome that permanent bar and still go on to get VAWA and permanent residence. The other is T status as well as U status. If you're here and you've been the victim of trafficking or the victim of a crime, then there is a waiver that's available, and it is discretionary, but the officer does have the ability to review the waiver and determine whether they're going to grant you the waiver to waive the permanent bar. Now, if they waive the permanent bar, then that means that once you're going on to get permanent residence, through adjustment of status based on the T visa or based on the U visa, that it means it's also waived for purposes of adjustment of status related to the T visa and the U visa. If you got this waiver based on the T visa or the U visa and then off the permanent bar, but then say you got married to a citizen and then you're trying to adjust through the citizen instead of adjusting through the T or the U, then that is not going to forgive that permanent bar. But if you go all the way to permanent residence after being approved, after getting the waiver approved, and then you go all the way to permanent residence based on the T or the U status, then at that point you could get the permanent bar waived. So those are two ways. And of course, there are other exceptions to the permanent bar where you're able to apply. You're not necessarily, you don't have to go through all the hoops, but I'm focusing on those two forms of relief today, is VAWA and the T. So even if you've crossed the border without permission, even if you have fraud or misrepresentation, and even in some cases, if you have a permanent bar, there are waivers that are available to forgive it and to help you to overcome those bars. Now, under other scenarios, so say you're going through the regular family-based or marriage-based immigration process, these are not available. These waivers are not available for those situations, and so you're in a tight spot. But if you do qualify for VAWA or for the T visa as a victim of trafficking, especially keep in mind though that also if you're in and out, if for example you're the victim of trafficking and you're in and out of the country, say without inspection, and that is related to the trafficking, that means that you can be forgiven for that permanent bar because it's linked to the act of trafficking. Same with being the victim of a crime. And so these are valuable forms of relief that can help you to move forward, help you to stay in the United States, and eventually get permanent residence here in the United States. So let's talk about qualifying for those, right? Because you may have just joined me and you may be wondering what is the T visa and what is VAWA. So let's start with VAWA. VAWA, if you have a U.S. citizen or a legal permanent resident spouse, a parent, or an adult citizen child who's 21 and up, they mistreated you, then you could qualify for VAWA if you're here in the United States, even if you're out of status. And in this case, even if you're subject to a permanent bar or inadmissibility. So, like if you've had past misrepresentation or fraud, if you've entered the country without permission more than once, if you've been deported and then returned and you have a permanent bar during the time of the mistreatment, if the permanent bar in regards to coming in and out of the country or being removed and coming back is in some way related to the abuse, then you could qualify for relief still and stay in the United States and get everything you need to stay here and live your life here and eventually become a permanent resident and US citizen. So mistreatment can be not only just physical harm or threats, it can also be verbal, emotional, financial as well, and extreme cruelty. So examples of a verbal abuse is where maybe they are calling you names, they're putting you down, they're embarrassing you in public by yelling at you. Emotional abuse is where they're being manipulative, they're being controlling, they're being jealous. they are embarrassing you, shaming you in public, or even in private. Maybe they call you names or make you feel bad about yourself. Financial, maybe they're making you work, and they're taking all your money. Maybe you have money in a bank account, and you find that they go draw all your money without permission. Maybe they are depriving you from working. They don't want you to work. And so they tell you if you work, they're going to leave you. You're going to be on your own. They threaten divorce. They get into a rage if you try to work, or if they start to threaten that, if and in this in regards to being controlling, if they start to say things like, if you don't do this, then I'm not going to file the papers. If you don't do this, I'm going to tell them that this is all a sham marriage when I go to the interview, or they threaten not to attend the interview with you, and you find that they're using this as a tool to control you, then it means that you could very well qualify for VAWA here, even if you're out of status, even if you cross a border without permission, and in some cases, even if you're subjected to the permanent bar, even if you're subjected to other types of bars, right? So if you're here with unlawful presence, you're here because you crossed you went ahead and say you left, you ended up coming back, and you're now subjected to the 3 year or the 10-year bar. So if you have any of these issues in your background, don't let it stop you from seeking assistance, because these are major problems, of course, in your immigration matter that we can still overcome in a VAWA application. Now, with T, if you've been the victim of trafficking, here's my rule of thumb, because the topic of trafficking is complex. But I do want you to know that under immigration law, and even in the law in general, trafficking comes in different forms. You typically, in the media, we hear about trafficking in a way where people are kidnapped from parking lots and then discovered, maybe in a basement somewhere, being held against their will, or they're forced to do sex work. And that's definitely one of the aspects of trafficking that does exist, but it is much broader than what is typically covered in the media. Trafficking, it comes in the form of labor trafficking. So, for instance, if you are in an employment situation where an employer has you, they're paying you very little, constantly find yourself indebted to the employer. The employer has you living at their place, working at their place, but at the same time, they're making you pay rent, and they're taking all sorts of expenses out of your pay. They're making you reimburse them for certain things. They're also at the same time telling you that if you leave, they have the power to call ICE, or they can do this to you because they are a citizen, or that you're undocumented, so they can do this to you. Then that does amount to labor trafficking as well, and you could qualify for T status. And T status means that you could also overcome bars like this, so misrepresentation or fraud in the past, or a permanent bar. In your background, we would submit a waiver to be able to get those forgiven, so you can continue on a path to get status here and then eventually permanent residence here. In the context of in other so not the trafficking isn't just an employer, not just labor trafficking, but say if you have an intimate partner who lured you here, and when they got you here, they started to put you to work. They maybe force you to give them some of their wages. They force you to do work. They force you to take care of their kids. They force you to have relations with other people. They force you to stay in the home even though you didn't want to, and have sexual relations with them. And while they're forcing you to do this, they're using certain tactics. They could be using a combination or one of coercion, where they're telling you, if you don't do this, all these bad consequences are going to happen to you. And bad consequences could be anything. You're going to be out on the street. I'm not going to give you your necessities like shelter, food, and clothes. I'm not going to, give you the ability to live, right? If they're not giving you things that you need. They're threatening to deprive you of things that you need. They're threatening to take away your children. They're threatening to go after your kids. They're telling you that if you leave them, they know where you are. They're taking your important documents, and you don't want to leave your documents like your passport or your birth certificate. So you try to stay until you can get those documents back. If this is an intimate partner that is doing this to you and forcing you to have relations with them, this is a form of trafficking, especially because you are being forced to do things you don't want to do. You're forced to stay in this situation. So they use coercive tactics to keep you where you are. That's a form of trafficking. And if they're using force, if they're telling you that they're going to find you and beat you up, that's also by force. And then also fraud. If they keep you where you are by telling you that, well, if you leave, I'm not going to marry you and I'm not going to get the green card for you. Or if they constantly say, well, you have to stay with me for 2 years and then I'm going to get the green card for you through marriage. This is also a type of fraud, or where they keep you where you are they keep promising you things that they are not providing and they don't intend to provide to you, and they're getting the benefit from you, but you keep hanging on thinking you're going to get the benefit that was promised from them. That is also a form of fraud, and it means that you could qualify for the trafficking. So trafficking does include not only just strangers that do this to you, not only employers, but also possibly ex-intimate partners or intimate people who you're currently in a relationship with, or maybe you don't want to be in that relationship with, but you feel like you need to be to survive or to be able to get what you need. Um, so if you're in that situation, go ahead, give us a call. You can get this even if you're out of status, even if you're currently now working without a permit, even if you cross the border without permission, even if you overstayed your visa, you can still obtain this. And of course, I'm talking about this VAWA and T status because there is the potential to overcome um, permanent bars, things that make you inadmissible, that under other circumstances you would not be able to get the benefit, especially while staying here in the US. VAWA and then getting T status does allow you to overcome those. So now that I've told you that, I've given you a solid pearl there. I'm going to leave it up to you to get in touch with me and to schedule an appointment so we can talk more about your circumstances and get started right away. This is one of the pleasures of my practice, is that I do help people who think that they're at the end of the road. They're really not, because of solutions like this that not a lot of people know about, and not a lot of immigration attorneys do point their clients in the right direction in pursuing these solutions. So go ahead, give me a call. We can talk about your situation and get started right away. Now is a good time to apply, by the way. So get started now. Treat your case with urgency, because with the way things are now, the political climate, things can change again, and things can get bad again for immigrants. So do it now while you can. Now, let's go to questions. I'm going to go through and I'm going to address your questions in the comments. So hang tight as I scroll through to your questions. All right. So I also see you there on YouTube and Facebook. So hang tight as I get through to your questions. So, can you divorce your ex-husband while VAWA case is pending? Now, what I would say is some of my clients, I do say, sure, go ahead. Divorce is possible while the VAWA is pending. What you can't do while the VAWA is pending is get married. Don't get married while your VAWA is pending. Don't get remarried while your VAWA is pending, because guess what? You'll get a big fat denial and you will lose your shot at getting your green card. So that's the one thing that of course, I advise my clients not to do it, but I've seen other colleagues talking about discovering that their client remarried during the VAWA processing, and because of that, they lost their shot. So you can divorce, because remember that is about your safety. Safety is number one. If you feel unsafe, you want to move forward with your life, remove yourself from the condition, remove your spouse from your life, you can do that via divorce while the process is pending. Now, I don't know what your situation is because, of course, I'm not your attorney. So I would not be able to advise you about whether that's a good idea right now. It really is on whether that's a good idea in this instance. It's going to come down to a lot of other factors here. So that's where it's important to make sure you have representation. You can go ahead, give me a call, and we can talk. If you're not currently represented, we can talk about your case. If you are, make sure you defer to your attorney. Your attorney knows best. All right. How many months does it take for the I-130 form? So I'm seeing 9 to 12 months to get that I-130 approved. If you're here and work for 2 years and pay taxes, can you file for yourself? I wish it was that simple. Unfortunately, it is not. While paying taxes here in the US is not a bad thing, it can serve as great evidence in the future. If you qualify for an immigration benefit, for example, that requires good moral character, or showing that you have maintained residence here in the United States by, you have to show continuous presence in the United States. Paying taxes is an excellent way to prove those elements. But paying taxes alone for a number of years is not going to be able to enable you to get permanent residence or to file for yourself. So if you're out of status, can you do it to do VAWA? Absolutely. Absolutely. 100% of my clients at this time who are applying for VAWA are out of status. I mean, except for the ones that do have the 2 year. But when we're talking about individuals who are applying for VAWA before they got the green card, 100% of them are undocumented. They did not have their official immigration status. This VAWA is for your protection if you're undocumented, if you came into the country without permission. Even as I said previously, if you have bars to admissibility, meaning you're inadmissible, you could qualify using a waiver, because they want to help individuals they want to empower individuals who are here without status, who are facing mistreatment or abuse, to empower themselves using the immigration process. So, absolutely, if you're out of status, VAWA can be a solution. You're welcome, Sharon. What is the outcome when USCIS denies adjustment of status based on verified divorce? So it depends. I don't know what the situation is, but if they denied it based on that, then you could reapply by proving your divorce. The reason they want to see they want to see evidence of a divorce is to confirm that you terminated any previous marriages before entering your current one, if this is marriage based. Because if you did not, it means that the current marriage is not valid. So because they don't do you can't marry, and in most countries on this side of the world, you can't marry multiple people at one time. You have to show that you first divorced before you can marry the next person. Um, What if I also have a child under 21? So if you have a child who's under 21, I forgot your previous question, but if you have a child who's under 21, you want to apply for VAWA, they can be included in your VAWA petition. Good morning. So let's see here. I see a number of questions. So I filed for I-751 recently and would want to know when one should expect to receive the receipt notice. So, I'm giving it 2 to 8 weeks to get the receipt notice for the I-751. And usually that initial receipt notice is also going to contain the extension letter, which they're doing for 80. They're extending the green card for 48 months. So if I am here and overstay my visa, can I get can I get an ID? No, not just after overstaying, you will not just be able to get your ID. uh, it's going to be very difficult. Now, there are some states that, they are lenient on those requirements. So, for example, if you can show that you're residing in the United States, you can apply for an ID, but you have to meet their requirements. So, you don't, those states, though, for example, Florida is not one of them. New York, Connecticut, Washington, California, those are states where you could potentially, it's not impossible to meet their requirements to get an ID and driver's license. And those are examples. One of these days, I'm going to just do some more research and pull up all the states that that do allow undocumented immigrants to get their ID versus those who don't, just to help out those who you want to, while you're here, you want to have some form of identification. So let's see. Good morning. Myself and my minor child got approved for VAWA. Which option do I select in part two of the I-485 for my child? He's here in the US. So I don't advise on specific lines on an application. I only do that. I don't even do that in consultations. I do that for my clients. And so if you are having doubts about your form, this is where it's important to get representation. It does make a difference. Hi there, Sharika Thorpe. So your name is very close to mine. Good day. So, okay, so I did answer that already. Um, you're welcome, Caroline. All right, so let's continue here. How long for work permit and AP after filing VAWA? So you could be looking at 6 months to a year after filing. Let's see. Just let me know. Can one person here just let me know if you can hear me? If there's no sound, I see one person saying no sound. Just let me know so um, I can come out and go back in if anything. All right. All right, so I see Sharika has a second part of, okay, great. So I'm glad you can hear me. So I see another part of Sharika's question, and it's, do I need an EAD for my child also? she's a minor here. So EAD doesn't necessarily mean that your child is going to work. It can serve as a form of identification for your child. Now, with children, if you want to have that alternate form of identification and get a social security number for your child, by all means, go ahead and submit that EAD for your child. Now, minors, when it comes on to things, they tend to be able to still live here as minors because getting into school is not based on immigration status. You can get into public schools still being an undocumented child, even though when it comes on to other aspects of life here, not having a social security number may be problematic to get your child on your benefits, to get certain things done for your child, sign them up for certain things. I have even seen where scholarship programs have turned down undocumented children. So if they've gotten academic scholarships, they may have to forego those opportunities because they didn't have the right documentation. So you just want to keep those things in mind, that life can still move forward, but certain things can get difficult when you have your child here. They are undocumented and they don't have the social security number or even a USID, a form of USID to get by. All right. Great questions so far. I'm just looking through to make sure I'm catching everybody's questions. If you married after your child's 18th birthday, can you add your child to your filing when you send your documents in? If you married a permanent resident, if permanent residents, you are able to carry your child who is under 21 and unmarried on the filing. However, if you married a U.S. citizen, then no. And that the U.S. citizen would not be able to sponsor the 18-year-old because you married the 18-year-old after you married your spouse after your child turned 18. So that means that they don't qualify as a stepchild for immigration purposes. You will have to file for your child when you get your permanent residence. All right, keep those questions coming. These are great questions. US says the divorce is unverified from the applicant's own country. Can that result? So this is where you need to get representation because it's getting more complicated here. If they are not accepting the divorce, then this could spell big problems for your application. So, when you have complexities like this, go ahead and schedule an appointment and get representation. Your intention here should be to get representation. When you do it yourself, especially when it gets complex like this, you're putting yourself in a losing position because you may not have the resources and the tools to address these questions the same as an attorney would. So if you got straight up denied, even if you're getting a request for evidence or a notice of intent to deny, because now they're questioning a divorce, it means that if they're questioning the validity of the divorce, they're questioning the validity of your entire marriage and your eligibility for permanent residence. So it means you're in trouble and you need to protect yourself by getting representation. It's worth it. For permanent resident spouse, can I stay in the US after entering with a visitor's visa and file for adjustment of status without being penalized for overstaying? That's possible. Now, if we would always get representation here. Can't stress that enough because where the problem starts is where you do it yourself. Thinking it's simple. But yes, it's possible. If you're married to a permanent resident spouse, the priority date is current. You end up here in the US on your visitor's visa. and you apply before your visitor's visa, your time expires here. Not now, a lot of people think I have a 10-year visa, it's not expired, right? So my time here hasn't expired. No visa is going to allow you to stay here for 10 years. The time you need to be looking at to determine when you need to apply is the time the officer has given you to stay in the United States. That time can range from days to weeks to up to 6 months. You can check that on your I-94. If you didn't get it stamped in your passport, check it online on the I-94. But you need to make sure that that adjustment of status application, once your priority date is current with your permanent resident spouse, is timely and properly filed before you end up overstaying the time you're permitted to be here. In that case, you will not be penalized for the overstay. Thanks so much, Sharon. So there's no way the child can be added to the application and you can complete the filing after you became citizens. So if you have further questions, go ahead and call and schedule your consultation, get representation. But what I will say is that if you have a US citizen spouse, you got married to the child after you got married to the citizen after the child was, or when the child turned 18, or after the child turned 18, that US citizen cannot, you can't include anybody. So when a citizen spouse is sponsoring you, you can't include anybody else on your application ever. You can't add anybody. It's just one of those things where the spouse of a citizen can't bring other people along. No dependents. If your spouse is a permanent resident, then in that case, sure. But I'm getting the gist here that that's not the case, that it's maybe a citizen. But if the permanent resident spouse is sponsoring you, then your 18-year-old could be added. I have a friend whose US citizen husband has a domestic battery case on his record from his previous relationship. Would that affect her in any way on her adjustment of status? It could. It depends on what's going on. The officers can look at the past criminal record and determine that in some cases, especially severe cases, that the immigrant may not be safe, and so they can't sponsor the immigrant. If this domestic battery involved a minor, then certainly that can be an issue under the Adam Walsh Act. So, make sure that your friend knows that they need to get legal advice. If you overstay on your visa and have a baby, how can you change status? So you can't change your status based on having a baby here. It does having a baby here while that baby is going to be a US citizen, it doesn't entitle you to get any kind of immigration benefits. When your child turns 21, then at that point, the child can submit a petition on your behalf to be able to make you a permanent resident. But right now, just based on having a baby here, it's not going to entitle you to any benefits. So if someone is over the age of 21 and and with your daughters and out of status for more than 5 years, what's the best option for them? So there's no easy option here. There may be options, but this is where I have found options for individuals like this is where I speak with them in a consultation because I'm able to delve into their circumstances. If you notice, when I come on here live, I talk about situations that are very fact dependent. Are you being abused? Have you ever been abused by an employer? Do you fear going back to your country? These require an extensive conversation and evaluation on my part to determine whether you or your daughters qualify for options here. So while there's no easy option just based on this, that you're here, you're out of status, you've been here for 5 years out of status, there's no easy option here. There are options available, but that's where the consultation is going to be very important for us to figure out. Hi there, Abigail. It's nice to see you. All right, so I think that's it for now. Thanks so much, everyone, for joining me today and for all of your solid questions. I will be back tomorrow to come with a topic, and then you come with your questions. And as soon as you hop on the live, you can go ahead and put your questions in the comments, and I'll address those questions. So, thanks so much for the love. Thanks so much for your questions and your time. If you want to get in touch with me, it's very, very easy to get in touch with me. If you send a DM, you are going to, I don't do legal advice in the DMs, by the way. Um, uh, if you want personalized legal advice, if you have a question, the best way to get in touch is directly to the office. At ST Law Office, that's the law firm that I work for. That's my law firm. You go ahead, go to the link in the profile. You can go to the link in the description of this video on Twitch, on Facebook, on YouTube. Go to the link in the profile on Instagram. Click on that link. It will give you every single thing you need to get in touch with me. You will have the link to the website. You will have the link to schedule your own consultation. You can schedule your own consultation without even calling the office, or you can call the office, speak with a scheduling coordinator. They will be more than happy to help you to do the consultation, to go through the consultation and schedule it. Now, Desmond asks, is your office in New York? So I'm based in Florida. But here's the good thing is if you follow me, you'll know that I do travel all around the country, and that's because I represent clients all in all 50 states and around the globe. So no matter where you are, it's still very easy for me to represent you because immigration offices are all around the country, and sometimes you may be in New York and you still have to contact the office in another state because that's the nature of the immigration. Is it's a federal practice, it's a national practice. So go ahead, give me a call. I can still represent you if you're in New York, and I do have many clients who live in New York right now. All right, so have a great one, everyone. I'll see you tomorrow. Bye bye.